Constitution Society. You know, it's great to see so many familiar faces here. I know that most of you are familiar already with ACS and our work, but you know, for those who might not be, I'd really like to encourage you to be sure to sign up for our mailing list. We'll have the mailing list sign up outside. It's a very low volume mailing list, I assure you. We'll just let you know about events that we do in town. And you know, the ACS is really about helping to advance a progressive view of the Constitution. And you know, I think as all of you know, the Constitution has been, some might say, under attack for some years by forces who want to restrict you know, its core principles and aim for a narrow reading of the Constitution. And I think the work that ACS does nationally and hopefully here in San Diego is important to get out our voices and our vision of what we believe the Constitution means and the principles that it embodies. Towards that end, we hold here in San Diego panel discussions regularly on issues of law and policy, networking events and happy hours, and of course this annual fundraiser. So my name is Alex Wright. I am head of the chapter here and professor at Thomas Jefferson School of Law, and I will be very brief in this introduction. I do want to make a few thank yous and recognitions. First, of course, I want to recognize all of the sponsors for this event. Without them, it wouldn't be possible. Robbins, Geller, Rudman, and Dowd, platinum sponsor of the event. Our gold sponsors, Eric Isaacson and Susan K. Weaver, and Bill and Michelle LaRock. Silver sponsors, Betty Boone and DNA Piper's LGBT Affinity Group. The bronze level sponsors, California Western School of Law, which of course was gracious enough to host us. I'd like to especially thank Joanna Sachs, a professor here, for making all of this possible for us to be here at Cal Western today. The Moore Firm, the Progressive Law Group, the Thomas Jefferson School of Law Center for Law and Social Justice, and the University of San Diego's School of Law. I'd also like to recognize our community partner, the San Diego La Raza Lawyers Association, and of course the ACS Executive and Advisory Boards, and the volunteers who staff the sign-in tables and been helping us out to make this event work today. I'd also like to recognize a couple of folks in the audience, the Honorable Margaret M. McEwen, Honorable Robert Coates, and Honorable Yvonne Campos, who also is a member of our advisory board for ACS. So we're really excited about this year's reception, you know, not only because we have such a fantastic speaker, but also because for the first time we're going to be presenting the San Diego Lawyer Chapter of the American Constitution Society Award for public service. And the award is named after Roberto Alvarez, who was a plaintiff in one of the very first school desegregation cases that's not as widely known as it maybe should be, but came from right here in the San Diego area. And we're especially fortunate to have Roberto Alvarez's son, Robert Alvarez, who is a emeritus professor at University UCSD. He obtained his PhD from Stanford in anthropology and taught at UCSD for the last 12 years, teaching anthropology in related areas. His current research is focused on transactional markets in entrepreneurs by looking at the ethnic fruit trade, primarily in the chili and mango markets between Mexico and the United States. And he's going to say a few words about his father's case and present the inaugural awards to the recipients. So join me in welcoming Robert Alvarez.
Thank you very much. I want to thank the ACS for inviting me here, and also that I'm learning something that I didn't know before about a San Diego chapter, and also to Alex and W who contacted me. I feel very honored to be here at my dad's wedding. It's very appropriate that this day, he passed away 9 years ago on February 20th, and today is my mom's birthday, who was also case, what I'm going to do is just briefly give you a little bit of background on the case. I think some of you know about the case, but I'd like to tell you how I found out about it, because most people think that because I'm Roberto Alvarez's son, that we knew about it when we were growing up, but we didn't know anything, and I learned about it when I was doing my PhD work here in San Diego on immigration. It's very appropriate, I think. This is a story about a Mexican immigrant community that had the guts and the courage to stand up in the 1930s during the Depression, when the Hoover administration was rounding up Mexicans and sending them back to Mexicans, citizens, U.S. citizens, as well as folks of Mexican descent back to Mexico. As you know, many of you know, close to 500,000 Mexicans and Mexican Americans were sent back to Mexico during this period of time. So it took a great amount of courage, I think, during this period. And what I want to say primarily is that my dad always talked about the case as being, once I learned about it, was not about him. It was really about the community. It was really about the families, not just the Alvarez family, but the Bonillas, the Gonzalez, Martinez, and a host of people that were residents of Lemon Grove. This was the first national desegregation court case in the United States, I found out. There were two cases before, one in Tempe, Arizona. It was Romo versus the Tempe School Board, and that was in 1925, but they lost that case. There was another one in Del Rio, Texas in 1930. It was Salvatierra versus the Del Rio, Texas. And they were really fighting Jim Crow laws at the period of time. Both those cases, actually the Salvatierra case was actually won, but it was overturned in a higher court. So the Lemon Grove case is very unique, because I think had it been contested, the Lemon Grove School Board would have won the case, given the time. If you recall, the 1930s, there were lots of Americanization schools in California, particularly in Southern California, where Mexicans were being separated from the quote-unquote American kids to be Americanized in special schools. And this was one of those cases where the Lemon Grove School Board basically decided to build a new school and send the Mexican kids to the new school. So in 1930, early 1931 actually, in fact this March it would be, I think, the 81st, is that correct? 81st anniversary of the school case. So in 1931, principal, his name was Principal Green, stood at the door and did not allow the Mexican kids into the school. And they were going to be sent to another school that was across the tracks in the Mexican area. However, the Mexican families had already known about this and organized. In fact, they organized into a group called the Vecinos de Lemon Grove, the neighbors of Lemon Grove. They organized, they went to the Mexican consulate and got some help, and they actually got a lawyer named Fred Noon, who was a family friend of the Gonzalez's in Lemon Grove. And anyway, they took the case to court, and eventually won it. And it was won on a very interesting legal note. The Mexican kids were classed as white. There was still segregation of Indians, Asians, and Black Americans, of course. But Mexicans, because they were white, in this case, it ruled a segregation case. The lawyer was Claude Chambers. He was apparently a very liberal man during this period of time, and was known to be a liberal guy. So let me tell you how I learned about this case. I was doing my PhD research here on the border, and I had decided to look at immigration because in my exams I discovered that immigration was treated as a non-human entity. People were pushed here and they were pulled in other places, back and forth across the border. And from my own experience, I realized this was very different from my experience. So I decided that I would kill two birds with one stone, do my PhD work, and look at my own family so that I could have something to give both to the committee as well as to my own family. So I interviewed my parents' generation, my grandparents' generation, and reconstructed the movement north. We're all mainly from Baja California, so we've been here a very, very long time. But in the interviews, people kept referring to the school thing, and I asked my dad, "What is this school thing everybody keeps talking about?" I said, "Oh, it was some show you the papers. My grandmother, Ramona Castellanos de Alvarez, had saved newspaper clippings from the San Diego Bee, San Diego Union, and from La Opinion, which was and continues to be one of the major Spanish newspapers, not only in the West, but in the country. And she also had, I don't know how she got them, but she had school board minutes that she had from the school board, basically outlined. It was just a couple of pages, but it was enough to illustrate that there had been, this work against the Mexican community. So taking it from there, I interviewed folks about the case. I actually got a small grant from the Spencer Educational Foundation, and my sister and I worked together, found the case in the county courthouse here in microfiche that was already deteriorating, and typed it up. Back then there were no computers, and we typed it up, and from there I reconstructed the case in the social context of what the case is all about. Both my mother and my father and the folks that were alive during this period of time always talked about it as something that their parents did. It wasn't they who did this. They basically, my father said, I just did what my parents told me to do. He was a good student. He spoke English well. That's why they chose him to be the plaintiff in the case. And some of you may know there is a film called The Lemon Grove Incident that was done by PBS. I was one of the co-producers with Paul Espinosa. It's been around for quite some time now. That my dad's actually in that film with other members of the community. But anyway, they were very humble about this case. And like the film, I wrote this article and I called it The Lemon Grove Incident. And when I look back now, this was done in the 80s, and when I look back now, I think that I was really mistaken about it being an incident. I look at it now and I think about the case in Tempe, Arizona. I look at the case in Salvatierra versus Del Rio in Texas. And also, just 13 years after the Lemon Grove case, we all know about Mendez versus Westminster, which was 13 years later. And we don't usually think about how Mexicans, Latinos contributed to Brown versus the board. But I argue, and I really think that the climate in the country at the period of time, the 30s and the 40s, especially in the Southwest, was one of great social movement. There were unions and so on that Mexican Americans were involved in. But the Mendez versus Westminster case is particularly interesting. Remember that La Opinion in Los Angeles was publishing articles about Lemon Grove. The families from Lemon Grove also wrote letters to the paper asking for financial support from other people. So it was something that was known throughout California. When Mendez versus Westminster went to court, a number of amicus briefs were written. The American Jewish Society, Japanese American League, and a few others. But the most interesting was that the NAACP sent in an amicus brief, and it was written by Thurgood Marshall. Similarly, if you think about who the governor was, that was Earl Warren at the time, and he signed into law here in California the anti-segregation measures here in California. And we all know that they ended up, both of them, working hard in the Brown versus the Board case. So I don't think it's just a coincidence that these cases have occurred and that these gentlemen later used some of these, I believe, some of these same arguments in the Brown versus the Board case. So it's a big thing. It's not, an incident. Anyway, that's my short tale. Again, it's really an honor to be here, and it's really an honor to be giving this award in my father's name. I know that he would be exceedingly proud and but very quiet about it, I'm sure. He was a very quiet guy. So I've got a little thing here that I'm going to read to give the award. Justin Brooks and Jan Stieglitz are the director and co-director respectively of the California Innocence Project, CIP. CIP is dedicated to releasing wrongfully convicted inmates. CIP is operated by a small staff and students who review over 2,000 cases from inmates each year. Students and attorneys work together to investigate facts and litigate cases to prove innocence. The process of overturning a conviction is one of the most difficult in the law. Professor Brooks and Professor Stiglitz oversee this process and work tirelessly excuse me, to secure freedom for wrongfully incarcerated individuals. Through their work, they have secured the release of a number of wrongfully convicted individuals and promoted justice and equality in the law. For these reasons, the San Diego Lawyer Chapter of San Diego wishes to acknowledge and honor their accomplishments with this great award. And I'm very honored to be the person to award the very first award, especially to these two gentlemen who are doing such important work. So I have to give
Jan and I are so lucky in the work we get to do and the kind of teaching we get to do. And we get to teach constitutional law in a really unusual setting. Like when you teach constitutional law standing in a classroom like this, which some of us in this room have done, it's all very theoretical and abstract. And we talk about these principles of Strickland versus Washington and principles of due process, and the students sometimes look half interested. If we're lucky. But when you have a student who comes to you and they've got a client who's in prison and they believe that that client is innocent, and then you have to start explaining to them and teaching them those principles, it's much more engaging, it's more exciting, it's a more interesting way to learn. It's also much more depressing. You know, when you have to explain to a student that, yeah, this lawyer really didn't do their job. We had a case where a lawyer entered a blind plea of guilty in a death penalty case. But knowing that that's not enough, that incompetence isn't enough, that you're going to have to show that it would have made a difference. And to teach them principles of due process of what our clients are entitled to in these cases, and see how difficult the burden is when we get these cases after people have lost their trials, lost their appeals, and they're at the end of the line. And to explain to the students that innocence is not enough in a constitutional context. And that kind of theoretical thing, if you wrote it on this board, innocence is not a constitutional claim, in a classroom, it's nowhere near as compelling as they just got back from the prison, they believe this person's innocent, and now we have to find something else. So we are very lucky. We've got some of our great students here tonight with us. And it is just such a privilege, and such a privilege to receive recognition like this as well, so thank you all.
We don't have the Academy Awards, the second person starts to speak. I just want to say that I thank you. I think the work is extremely important. There's nothing that's happened to me professionally that's been more rewarding than walking someone out of prison. And there's been nothing for me more professionally devastating than losing the case. It's important work, and we appreciate both the support and the recognition. Thank you very much.
Thanks so much. And we're, our chapter is just so fortunate and happy to be able to honor such deserving recipients with this award, and that the Alvarez family was so kind in letting us name the award after Roberto Alvarez. When we were thinking about, well, what will we name this award, we thought, wouldn't it be nice if we could find some case in San Diego history that really exemplified what ACS stands for, and then we actually found the very article that Robert Alvarez wrote about his father's case, and it's just so fantastic. So, two other very quick things that I forgot to mention, but one is if you're not an ACS member, please do go online, become a member. I think it's only $35 or something like that. There's going to be the ACS annual convention in Washington, D.C., June 14th through the 16th, which is always fantastic. Brings folks, amazing speakers on panels from all across the country. So that's something to keep on your radar. And if you have any questions about these things, Nick Alexiou from the national office in DC is right over here, and I'm sure he'll be happy to answer any and all questions that you might have about becoming a member or getting out to the conference in DC. So with that, I'm going to introduce Judge Yvonne Campos, who will introduce our keynote speaker, Pam Carlin. Judge Campos was appointed to the Superior Court in 2003 by Gray Davis. She is a graduate of Harvard Law School and earned her bachelor's degree from Stanford. She is also a member of our advisory board and really a fantastic person to have in the ACS network here. So please join me in welcoming Judge Campos.
Thank you, Alex. It's so nice to see so many friends here tonight. And it's my pleasure to introduce to you a legal rock star, Professor Pam Carlin. If you've picked up a program, I'll gloss over what you'll find out about her in the program, or you can grab one later. She is currently the Kenneth and Harl Montgomery Professor of Public Interest Law at Stanford Law School. She's also the co-director of the Supreme Court Litigation Clinic at Stanford Law School. She has argued before the Supreme Court, and she has also clerked for the Supreme Court. She had the opportunity to clerk for Justice Blackmun, and in fact, I believe that in an oral history, he acknowledged that it was her excellent analysis and writing that led to his dissent in Hardwick versus Bowers. She is I guess a triple Yaley, earned a trifecta of degrees from Yale, and then she got her bachelor's, her master's, and her Juris Doctorate from Yale. And she was most recently last semester back at her home campus of Yale, teaching at their law school. But we've got her back in California, and she's gracious enough to support ACS nationally and also to make it to a number of the Western chapters. It's my privilege to introduce my friend and a legal rock star who I first noticed during the 2000 elections when she was doing commentary that was giving us hope in those bleak times. Let me give you Pam Carlin.
Short-lived hope. Thank you so much for having me down here tonight. It's actually a little bit of a bittersweet occasion for me. I used to come down to San Diego quite a bit to visit Harl Montgomery, whose generosity in endowing, along with her husband, the chair I sat in, enabled us to start the Supreme Court Clinic at Stanford. And we're incredibly grateful for that, in part for reasons that are connected a little bit with something that Professor Brooks said, which is that a lot of criminal defendants at the Supreme Court receive really terrible representation. And part of what our clinic has done is to represent people at the Supreme Court who weren't represented well below. And occasionally we win, although a lot of the time we lose. You know, as Justice Brennan used to say, 5 votes beats a reason any day. There's a wonderful line in Philip Larkin's poem, Bridge for the Living. It goes like this. It says, reaching for the world as our lives do, as all lives do, reaching that we may give the best of what we are and hold as true, always it is by bridges that we live. That, in a nutshell, is what ACS is about. It's about building a network, building bridges between this generation of legal scholars and the next generation of legal scholars, between this generation of lawyers and the next generation of lawyers, between lawyers in different practices, and between lawyers, courts, and the government. With chapters in almost every accredited law school in the country, we're providing students with programming, with mentors, with career guidance, and with an ability to debate some of the most contentious issues that arise in the law today. And our professional chapters, like the chapter here in San Diego, enable lawyers in practice to remain connected both to ideas outside of their practice and to meet people outside of their practice areas. And I can't tell you for myself how important that is. And I urge you to go to the National Convention if you've never been there, because it's a fascinating opportunity to learn about areas of law that are not the area you practice in, but that have connections that you'll start to see that can have a real effect on how you think about legal issues in your own area. It's a chance to kind of revitalize yourself and to feel that you are not alone. Because a lot of times I think those of us who are doing liberal or progressive or left lawyering find ourselves feeling like we're often alone, and that's a hard thing to be. Now, giving the best of what we hold is true, ACS members shape debates on key legal issues. They write about these issues for ACS in issue briefs and other kinds of publications. They write in ACS periodicals, and they also help to write amicus briefs and the like, and put together testimony to go in front of Congress. And I think these help to make a real difference, because it takes a lot to move the Constitution back to what we think the Constitution should be about. I started law school the year that Ronald Reagan was elected president. I don't take responsibility for that. There's a causal relationship, but that's the year I started law school. And that was also the year that Attorney General Ed Meese in 1981 started a process called the Constitution in 2000. That was a self-conscious effort to try and shape the Constitution for the year 2000 in a way that would move us towards less regulation, less social justice, less fairness to criminal defendants, and a host of other conservative positions. ACS has been involved, as many of you may know, in a project that we're focusing on somewhat this year called the Constitution in 2020, which is an attempt to move the Constitution back to the Constitution as our framers understood it, and as the second framing generation, the Reconstruction generation, understood it. And I think that's one of the real things that we have to combat, is this idea that the Constitution is mostly about what happened in 1789. It's not mostly about what happened in 1789. It's about 1789, but it's also about 1865 to 1868. It's about the New Deal as much as it is about the framing generation. And so I've been asked tonight to make a couple of remarks about the Constitution and constitutional law, and I thought I would talk about a recent Supreme Court case that illustrates some of these issues, and illustrates some of what we're trying to do and some of what the kinds of arguments that ACS stands for are about. So last term, not this term, I'm going to kind of lead into this, right? You have to have an intro into your time. But last term, there was a case in the Supreme Court that many of you may know about that involved a challenge to a California law that made it a crime to sell violent video games to minors without their parents' consent. And during the oral argument, Justice Scalia was pressing the lawyer for the state of California about whether there was a history, going back to the framing, of regulating speech about violence. And the lawyer for California was having some difficulty in the back and forth with the justice, and finally Justice Alito leaped in and said, what Justice Scalia wants to know is what James Madison thought about video games. Now, if that really had been the question, the court would have upheld the California law, because even the most imaginative of our framers did not foresee interactive electronic game consoles. So it's hard to imagine that they foresaw regulating or forbidding the states from regulating something they couldn't imagine at all. I mean, if we ask, what would the framers have thought about Grand Theft Auto, they would have thought Grand Theft Horse and Buggy. But they would not, they wouldn't have known from this. And yet the Supreme Court, in an opinion written ultimately by Justice Scalia, held that video games qualify for First Amendment protection because they're a form of expression that communicates ideas. And Justice Scalia reminded us that whatever the challenges of applying the Constitution to ever-advancing technology, the basic principles of freedom of speech and of the press do not vary when a new and different medium for communication appears. I know you did not think I was going to quote Justice Scalia tonight at the ACS event, but we have to encourage him when he does that. Now, the Supreme Court is frequently called on to apply the Constitution to situations and devices about which the framers could not even have dreamed. Justice Oliver Wendell Holmes was right when he said that the Constitution has called into life a being the development of which could not have been foreseen completely by the most gifted of its begetters. It was enough for them to realize or to hope that they had created an organism. It has taken a century and has cost their successors much sweat and blood to prove that they created a nation. And the additional century since Justice Holmes wrote that has only illustrated this point further. Now, Alex said something earlier about, needing to take the Constitution back. And so I want to point to something that many of you saw on television, and you probably snickered in a way about it, or you laughed, or you thought it was a cynical political joke. And that is when the House of Representatives opened its session in 2011, they went up and read every word of the Constitution, one after the next. Now, they didn't actually read every word. They cut out the parts that nobody wanted to get up and read, like the 3/5 clause and the you can't ban the importation of persons clause. But they read a lot of the clauses of the Constitution. And everybody thought this is a cynical political ploy. And to some extent it was. But there was one thing about it that I urge you to get on YouTube and take a look at, because it's really important, and it also illustrates a point that Mr. Alvarez was talking about earlier tonight, which is most of the reading of the little chunks was done first come, first serve, and there was a lot of jockeying among the members of Congress to line up and do like the, nobody wanted to do the 16th Amendment, right, the income tax. Nobody wants to be up there talking about the income tax. But there's a lot of jockeying, but each side got to pick 2 members to speak out of order, that is, they got reserved slots. And I think the most moving moment of this entire process was one of those slots, which is when it came to the 13th Amendment to the Constitution, the amendment that abolished slavery in the United States. The person who was called on to read that was Representative John Lewis from Georgia, who as a college student was one of the leaders of the Selma to Montgomery March, and who probably did more as a college student to make the words of the Constitution real than any member of Congress has done in the history since John Bingham actually proposed the 14th Amendment. And it reminds us that the Constitution is made not just by the courts and not just by the original authors, but by people in the streets, people like John Lewis, people like Roberto Alvarez, and people like us. And so I'll tell one kind of personal story that Yvonne alluded to. Which is the year I was clerking at the Supreme Court was the year of Bowers against Hardwick, in which the Supreme Court held 5-4 that gay people have no right to engage in consensual, private, adult sexual activity. I was also in the Supreme Court, in the chamber, in the courtroom, for the argument in Lawrence against Texas in 2003, when the Supreme Court held that the liberty protected by the Constitution protects all people, not just straight people, in their right to have intimate sexual relationships. Now, what changed between those 2 periods of time? It's not the words of the Constitution that changed. The words are the same. I mean, to be honest, the words aren't exactly the same because the 27th Amendment, the one about no pay raises for Congress, got ratified in the meantime. But the relevant words are exactly the same, right? The 14th Amendment didn't change. But here's what did change. If you were at the oral argument, as I was in Bowers against Hardwick, Justice Powell asked questions from the bench, like, if you let gay people have sex with each other, aren't they going to have sex in bathrooms? Aren't they going to have sex in cars? What about in, movie theaters and the like? And then he went back, and the justices all go into a room, and it's just the 9 of them in the room, and they talk about the case. And when they got to Justice Powell, he turned to the other 8 justices in the room and said, I don't understand this at all. I've never met a homosexual. And Justice Blackmun, who was in the room and used to come back and read his notes to us, and the only reason I can tell you is, so don't worry, Judge McCune, it's not like I go around telling people everything, is this is all in Justice Blackmun's papers, which he left to the nation, and they're all open, so I can tell you what's in the papers now, because he's told me what's in the papers. Otherwise, I wouldn't have said anything. But what happened is Justice Blackmun said, and then Lewis Powell said, I don't think I've ever met a homosexual. Whenever I hear Justice Blackmun's voice, I always hear like Justice Blackmun being imitated by Garrison Keillor, doing an imitation of other justices. So Justice Powell said to them, I don't think I've ever met a homosexual. And Justice Blackmun said, and I felt like saying to him, Lewis, look around your chambers, for God's sake. And that was 1986. Now, what was the difference in 2003? Well, when we got to the Supreme Court in 2003 for the oral argument in Lawrence against Texas, The man who argued the case for John Lawrence was Paul Smith, the head of Lambda, who was an openly gay man and a former clerk to Justice Powell. And if you looked in the courtroom, almost every LGBT clerk in the history of the Supreme Court had come to watch the argument. And they were all sitting in the bar section. And when the justices came out from behind the curtains, you could see them look. You could see Justice O'Connor, and it was like... So after the oral argument and before the party, I was standing around in the courtroom with Walter Dellinger, who'd been the acting Solicitor General during the Clinton administration, and Linda Greenhouse, who was the New York Times reporter, who covered the Supreme Court for many years, came over to chat with us. And she said to Walter, what did you think was interesting about the argument? Walter said something, and then Walter said, Linda, what did you think was the most interesting thing about the argument? And Linda looked at him and said, the bar section. Now here's what that was about, is the justices came out to the courtroom and they saw people they knew and they respected and they liked and whose commitment ceremonies they had gone to and whose partners they had met, and that made a difference in how they understood liberty. And that's what changed the Constitution. It was not like we found the Rosetta Stone and it turned out that James Madison secretly believed in same-sex marriage. I mean, if you had, the man's wife brought ice cream to the United States, and her favorite flavor was apparently oyster. So it's not that these people weren't a little bit countercultural, but still, they did not know anything about this. They did not think about this. The Constitution changed because people's views changed. And so the reason that the United States Constitution is the most enduring constitution in the world, the average national constitution lasts 17 years before it gets scrapped and they bring out a new one. The reason the United States' Constitution is the most enduring constitution in the world is not what 55 white men did in a hot room in Philadelphia in 1787. Whatever it was. Rather, it's the way that generation after generation of Americans has made the Constitution ours. The Constitution endures because its meaning and its application have been shaped by an ongoing process of interpretation that is a dialogue between the courts and the people. That's what makes our Constitution a Constitution that endures. Its words and its principles still resonate centuries after they were written, because time and again, as Justice Holmes also reminded us, we have interpreted the Constitution in light of what this country has become. Now, when it comes to technology, the Constitution and technology can cut in both directions. Sometimes, as in the video games case, or in another case from California that involved text messaging by a police officer in Ontario who made the mistake of using his city-issued pager both to text his wife and to text his two girlfriends. Here is a pointer for you. Do not use your city-owned pager to text your girlfriends if you also have a wife. It can cause problems. Right? In cases like that, the question is whether new technologies can invoke constitutional protections. That is, can you invoke constitutional protections to deal with new technologies in the same way as old ones, like writing a letter or keeping a diary or the like. Other times, as with the case I want to talk to you about, United States against Jones, the issue is whether traditional understandings can survive the government's use of new devices. Now, Jones involved the federal government's placement of a GPS device on the undercarriage of Antoine Jones's car. It was a device that provided the police department with a record that was 2,000 pages long, giving the car's location and its movement every 10 seconds for a month. At the end of the day, this ream of paper, and I mean ream of paper literally, enabled the prosecution to show at Jones's trial for conspiracy to distribute cocaine that his car had repeatedly traveled to a stash house where large amounts of narcotics had been found, at times when other people who were then taking the narcotics and dealing them were also there. Jones argued that the GPS data should not have been admitted at his trial because the GPS device had been put on his car without a warrant. There actually had been a warrant, but the warrant had expired and the government had not renewed the warrant. It just went and took the device and slapped it on the chassis without getting a new warrant. Now, the question before the Supreme Court was whether putting a GPS device on the chassis of someone's car constitutes a search within the meaning of the Fourth Amendment. The government's position in the case was straightforward, and I want you to understand, this is the Obama Justice Department's position in the case. Their position is there was no search here at all, because the Supreme Court long ago held that Fourth Amendment protections are not triggered when the government looks at what a person knowingly exposes to the public. For example, police don't conduct a search if they follow you on foot down the street, because anybody could follow you on foot down the street. So when the police do it, it's no different. There's no search there. Or if they stand near you on the street and sniff and notice the odor of marijuana wafting off of you, they don't conduct a search. There are an amazing number of cases in which the police stop somebody and then say, and then I was struck by the overwhelming smell of marijuana, and that's what led me to arrest that person and search him. So here's another hint for you. Don't walk around giving off the overwhelming hint of marijuana. Or if you are like a client I represented at the Supreme Court, do not go to the police station with methamphetamines in your pocket. So, in the government's view, a GPS device is no different than a little policeman hanging on to the bottom of your car. So if a policeman could have followed you 24/7 for a month, then having a little mini policeman underneath your car, like a Garfield doll. Think about those Garfield dolls that are like stuck on the sides of people's cars. So this is like a little mini policeman underneath the car. He can hang underneath the car that whole time, sending a report every 10 seconds back to somebody who's sitting in a comfy room somewhere at police headquarters. But as Justice Sotomayor recognized in her concurrence in Jones, and as Justice Alito sort of implicitly acknowledged, the new technology may mark a difference in kind and not just in degree. That is, privacy was traditionally protected not just by legal principles, but by practical constraints on what the government could do. The sheer cost of round-the-clock surveillance by a team of agents who would never lose your car, you know, as you went out one entrance while they were at another, or as they had to stop to get a donut, and took off while they were doing that, meant that few people faced a realistic threat of being surveilled and targeted by the government 24/7, right? I mean, maybe a terrorist or a suspected terrorist would have to worry about that. But the average person, even the average person who might be engaged every now and then in something that was a little illegal, didn't have to really worry that they were going to be the subject of 24/7 surveillance by the government. But a GPS system changes the calculus, because instead of it actually costing the government very much, for pennies a day, the government can figure out where you are every 10 seconds. And that new technology creates an entirely different set of incentives and cost-benefit analysis for the government. Right? The government can engage in pervasive monitoring now at no cost to itself. And within a couple of years, it'll be even less cost than that. They can put a tiny device on everyone's license plate before the state issues your license plate. And then they can just turn it on anytime they want. And a computer can data mine everything, so you don't even have to have an officer sitting there looking at it. The computer can just cross-tabulate this with records from your phone company and records from your credit card company and other people's phone and credit card and car records to figure out who you're with, what you're doing, all the time. Now, if the court had concluded that the police use of a GPS device didn't constitute a search, then all levels of government would have been free to install GPS devices without warrants, without having probable cause to believe criminal activity was afoot, indeed without any suspicion of any kind at all. And in oral argument, the justices recognized this problem. Indeed, if you're free to attach GPS devices to people's cars, because after all, their cars are out in public, and it's not a search to look at what they're doing out in public, why not just attach GPS devices to everybody's parka and everybody's raincoat? Because after all, like, what kind of person wears a raincoat inside? Right? Almost all the time that you're wearing your raincoat, it's exposed to the public. So why not allow us to put a GPS device on everybody's raincoat and just follow them around all the time? Now, several years ago, law professor and ACS member Jack Balkin described a new form of government that relies on the pervasive gathering and data mining of information about large groups of people as the national surveillance state. And what United States against Jones was about was whether there was going to be any constitutional constraint on the national surveillance state at all. Now, a month ago tomorrow, the Supreme Court issued its decision in United States against Jones, and you will be happy, if you don't already know this, to learn that all 9 justices thought there had been a search here. But the opinions that they issued give us a sense of the complexity of how to think about this issue, and to how to think about constitutional interpretation more generally. Justice Scalia wrote the opinion for the court. In his opinion, joined by the Chief Justice, Justice Kennedy, Justice Thomas, and Justice Sotomayor, held that the act of attaching a GPS device to a car and monitoring it constitutes a search under the Fourth Amendment because the government engaged in a trespass. That is, in 1789, it would have been understood that a trespass constituted a search. And this device trespassed onto Jones's car, in the same way that an older Supreme Court case called Silverthorne held that if you took a microphone and shoved it into the outside wall of a house so that it could get conduction, so that talk inside the house would be conducted through the pipes, and you could then listen because the microphone was right near a pipe, that constituted a search. So it was the putting of the thing on the chassis of the car, and in the 18th century this would have been understood as a search, so it's a search today. Well, that's all fine and good for the time being. That disposes of Jones's case, but it doesn't do much to tell us what we really should care about today. Because it sheds no light, for example, on what would happen if the government, instead of attaching the GPS device to the chassis of the car, embedded it in the license plate. Because if it embedded it in the license plate is actually owned by the government. You don't own your license plate, the government owns it. And if they put it on it before they put it on your car, it would be like the beeper cases that some of you probably know about, like United States against Carroll, where if you get a barrel of chemicals and the beeper's already in there, you don't have a claim that there's a search, because the person who put the beeper in the barrel is the only person who could do that, and they consented. So it means that drones or cameras everywhere in public areas would not be a search, because after all, that's not a trespass on your personal property. There would have been no problem in the 18th century with that, although of course they didn't know from cameras and GPS devices. Now, the other thing to understand about this is physical privacy is not the major problem today. The major problem today is informational privacy. The problem with the GPS device on the car here is not that the GPS intruded a fraction of an inch onto the chassis of Mr. Jones's car so that somehow the chassis was compromised. I mean, I'm sure his car kept on rolling for a whole month while he went to the stash house again and again and again. Instead, the problem is that the GPS device provided literally reams of information about Mr. Jones's life and what he was doing every minute of the day. Not just when he was engaged in criminal activity, but presumably when he went to church, when he went to the store to buy things, if, like Mr. Kwan in City of Ontario against Kwan, he went to visit his girlfriends and his wife, right? And that stuff, that's really important to keep private. And that's stuff that Justice Scalia's opinion doesn't confront at all. Now you might think, okay, well, what about the other opinions? Now Justice Alito wrote an opinion concurring in the judgment, and he was joined by Justices Ginsburg, Breyer, and Kagan. He reached essentially the same bottom line, there in the search here, but he strongly disagreed with Justice Scalia's reasoning. Instead of grounding analysis of a 21st century surveillance technique in what he called an 18th century tort, Justice Alito would have relied on a framework that the Supreme Court laid out in Katz against the United States in 1967, which said that the Fourth Amendment protects reasonable expectations of privacy. And if the government violates a reasonable expectation of privacy, then they've conducted a search. Justice Alito's analysis was consciously flexible, It recognized that society's expectations might well change, which is, he also recognized that in a society in which people expose more and more of their information to other people's view in a variety of ways, maybe we'll end up with less protection rather than more. That is, protection of privacy is not a one-way ratchet. If you're prepared to hand over reams of your information to other people, then you don't have any expectation of privacy in that information anymore. And all of you are turning over reams of information all the time. I don't know how many of you listened to Fresh Air today, the NPR program. But on Fresh Air today, Terry Gross was talking to a guy who's written a book about how advertisers now are taking huge amounts of information from your surfing the web to figure out exactly who you are, what you want, and how to sell it to you. Well, all of that information that's in third-party hands, the government can get access to without a warrant, because you've already waived your right to privacy over that information. If you your bank records are not something that, it doesn't constitute a search under the Fourth Amendment for the government to get your bank records, or to get records from your internet company. There are statutes that regulate that, but it's not regulated directly by the Fourth Amendment because you've already given the stuff to third parties. It's not private in the same way. And that's because we don't understand, or we don't think about what goes on the internet the same way we understand a letter is, which is, when you write a letter to a friend, if the post office opens it, that's a search. Why don't we have the same understanding of the use of new technologies? And of course, for a generation of people, even younger than the youngest people in this room, who put everything up on Facebook, there's yet another set of questions about what is your reasonable expectation of privacy under those circumstances. So Justice Alito's opinion, while at least it recognizes we need to think about what the Fourth Amendment means today, and not just ask, what would have happened if a tiny constable had been put underneath your coach in 1789, he doesn't really solve the problem. And part of the way he doesn't solve the problem is he says, in his opinion, that relatively short-term monitoring of a person's movements on public streets, even with a GPS device, does not constitute a search. So now we need to figure out, well, for him, at least for Justice Scalia, anytime they put this GPS under your car, it's a search. For Justice Alito, maybe they can put the GPS under your car, they just can't have it under there for quite this long. But he doesn't tell you how long is too long. He leaves that open to future cases. So his opinion provides a different and not simply more protection than Justice Scalia's. Finally, although Justice Sotomayor joined Justice Scalia's opinion for the court, she also wrote a separate concurring opinion. And I highly urge you to read this opinion if you haven't read it yet. It's a terrific opinion. And I think it does a wonderful job of showing how the Constitution should be interpreted to deal with contemporary problems. Because she stakes out the most privacy protective approach. And she notes that the information revolution has changed the threats that people face from government surveillance. She explains that even short-term GPS monitoring could provide the government with what she called a wealth of detail about a person's familial, political, professional, religious, and sexual associations, and that aggregation of data could be aggregated and re-aggregated and mined down the road for years, perhaps killing fundamental associational and expressive freedoms. And she expressed a willingness to reconsider the premise that the court has long relied on, that an individual has no reasonable expectation of privacy in information voluntarily disclosed to third parties. As she recognizes where the threat to privacy comes from today, and says we need to rethink whether the simple fact that third parties have your information in their databases or on their computers or on their servers means somehow you've waived all constitutional protection. Now, in many ways, the decision in Jones was a victory for Fourth Amendment values, because had the court come out the other way, it would have been a disaster. But the decision leaves open a host of questions as well, ranging from technical questions like, is the use of a GPS device the kind of search that invariably requires a warrant? Or is it like a Terry stop, something that you can do if you have only reasonable suspicion or the like? to really quite profound questions, like how we should understand privacy in an electronic age. Now, in many ways, the foundation of modern Fourth Amendment law is Justice Louis Brandeis's dissent in Olmstead against United States in 1928. There, in explaining why wiretaps, despite the fact that they involve no trespass in the target's home, should be treated as a search, the justice wrote, "Time works changes, brings into existence new conditions and purposes. Therefore, a principle, to be vital, must be capable of wider application than the mischief which gave it birth. That is particularly true of constitutions. And it's particularly true of how we should understand the Fourth Amendment today." Thank you very much. Alex said that I should take a little time for questions if anybody had them, which I'm glad to do. So, yes, sir.
Thank you. Thank you for coming here to San Diego. I noticed your view about how long constitutions last, and Justice Ginsburg spoke in Egypt recently about whether the United States Constitution is viable in the 21st century as compared to more recent constitutions. South Africa and Canada were pointed out particularly. What are your views about that?
So it's actually kind of interesting. I mean, if you look at modern constitutions, there are some parts of them in all of the emerging democracies and then in well-developed democracies like Canada, which just happened to come up with a constitution late in its history. There's some parts of those constitutions that borrow tremendously from the U.S. Constitution. Most of the rights provisions in those constitutions borrow quite a bit from the U.S. Constitution. So freedom of speech, the press, religion, equal protection and the like. Here's what none of the modern constitutions have, which our constitution is. None of them has set up a government system that is as likely to gridlock and deadlock as ours. And in which, if you read the U.S. Constitution, you will discover the only currently existing unamendable provision in our Constitution is the provision that says every state gets 2 seats in the Senate and there's nothing you can do about it. I mean, there's going to be a point sometime a century or two from now when there are only 3 people in North Dakota and none of them is there because they're all serving in Washington. The senators and the representatives. So there are parts of our Constitution that we would never have adopted if we were adopting a Constitution today, right? Virtually no country in the world elects its national legislature the way we do. Nobody. Right? None of the emerging democracies in the world decided to use single-member districts drawn by politicians to elect large parts of their legislature, because that is not a particularly great system. I don't think we can change those parts of our Constitution, and in some sense, constitutions in this sense are always kind of path-dependent. That is, the Constitution you have determines the politics you have, which then determines what you think about what the politics you could have. And one of the things we've learned in the United States, and in California we've learned it with a vengeance, is if your Constitution is too easy to amend, it might be just as bad as if it's too hard to amend or change. When I teach I teach a constitutional law class at Stanford that's for students in graduate school who are not in the law school. It's part of a course that's called Thinking Like a Lawyer, and I do a couple of days on Constitution. And I always tell them the story of Hugo Black, who used to, always carry around a copy of the U.S. Constitution in his pocket. And then I pull out a little pocket Constitution and I show it to them, and I make a joke about pretentious law professors who carry around a copy as if they were Hugo Black. And then I say, but California has a Constitution too. And then I pull out a copy of the California Constitution, which is in a book that's like this, and it's like this thick. And then I start reading them some random provisions from the California Constitution, and it's appalling, right? So, I actually don't think our Constitution is a terrible Constitution. I think it's a great Constitution in many ways, but it has some serious flaws in it that can't really be addressed because the provisions are so literal that there's nothing you can do if you can't get an amendment to the Constitution, right? We can't move to a parliamentary system in which the party that controls the legislature is going to have to take responsibility for what goes on in the legislature, because if they don't pass anything, the voters will know it's their fault. We can't do that because we have a separation, right? right? The Electoral College is here to stay, whether you can do workarounds or not. I'm a little not so sanguine about that. There are a couple of other provisions in the Constitution that I think are also problematic. One which we should be able to amend, but not in this climate, is the one that says that citizens can't become president unless they were native-born citizens, which I think everybody who thinks about it for a moment would understand is a terrible provision today. Because if the American people don't think somebody's become American enough to be president, they're not going to vote for them. We don't need to exclude people like Jennifer Granholm from the presidency in order to make sure that we're not invaded by a foreign country. You know, Canada. We don't have to worry about that. So there are some pieces of the Constitution that, yeah, we would get rid of them, I think, if we could. But opening up the whole Constitution would be incredibly risky, especially in the current climate. I would rather stick with the Constitution I've got, even if some parts of it are things I don't like very much. So, and I think part of what Justice Ginsburg was getting at was that general point, that there are parts of our Constitution that other governments have thought more clearly about. But of course, they got a lot of that from looking at lessons from the American Constitution, so it's not like we haven't contributed. Yeah, in the back.
Could you say just a couple words about the Supreme Court decision that a corporation is a person that will help me as a layman understand that decision?
Sure.
I'm a minister, I'm not an attorney, but I would really like to understand that decision.
Sure.
So if you could just say a couple words that would help me, I would appreciate that.
Sure. So the question, I actually think corporations are in some sense persons. That is the problem with I think what you're alluding to is the Supreme Court's decision in the Citizens United case that corporations are persons and therefore they should have a right to spend unlimited money trying to influence elections. You can disagree with that view, that corporations should be able to spend limitless amounts of money to influence elections, while still believing, as I do, that corporations are entitled to some of the protections that are given to persons under the United States Constitution. So let me explain why that is. Corporations, the word corporations covers an awful lot of different kinds of entities. So General Motors is a corporation, but so is the American Civil Liberties Union. So I would guess, what church are you?
Plymouth Congregational Church is
Congregational
a corporation.
Church is a
Yes.
corporation, right?
Yes.
And so if you were to say that neither a church, nor the ACLU, nor the National Rifle Association, nor a union, nor GM was a person, then they wouldn't be protected, for example, by the due process clauses of the Constitution, which say you can't take a person's liberty or a person's property away from them without due process of law. So the government would presumably then be entitled to take away the ACLU's property or to take away the liberty of another ideological corporation without giving them any due process rights. So the Supreme Court's recognized since the 1880s, since the Southern Pacific case, which was in the 1880s, that corporations are, for some purposes, persons. That does not answer the important question, which is they are persons, but they are a different kind of person than natural persons. Because, for example, generally, unless a natural person has committed a particular kind of murder, you cannot execute a natural person. You can execute a corporation like that. You can liquidate a corporation. They use the word liquidate, that kind of Stalinist word if we were talking about people, you know. We liquidated him. That sounds really bad. We liquidated a corporation. It happens every day, right? You can't put a corporation in jail. But corporations are organizations of people. They're different, though, in important ways. They get treated differently under the tax code. They have perpetual life. They have limited liability. Many of them get their money in ways that are different from the way that natural people get their money. And so I think that regulating how corporations speak in the political process differently from how natural persons speak is eminently sensible. But you can't even there say, well, okay, if it's a corporation, it shouldn't be allowed to participate in politics at all. Because, of course, what do you do then about media corporations, which want to endorse candidates? Or like, do you say the New York Times can't endorse a candidate because it's a corporation? or Fox News can't run unfair and biased, or whatever their slogan is, coverage because they're coverage. So it's actually a very difficult question, because the question I don't think can be answered by saying corporations are not people. It has to be answered by saying, what is it about corporations that leads us to think they need to be regulated differently in the political process? And one of the things I do a lot in my academic work is I write about elections and campaign finance and the like. And here's the thing about money in politics. Money is like water. If you squeeze it out over here, it will come back somewhere else. And because of the Supreme Court's decision in a case called Buckley against Vallejo in 1976, where they said you can limit contributions to candidates because we're worried about corruption, but you can't limit independent expenditures on politics at all. What has happened is after 40 years of reform, 35 years of reform, we have a political system where money plays a worse role than it played at the time of Watergate. The money today is in far worse. It's going to super PACs where you don't know where it's coming from. It goes to single issue groups. It's destroyed the political parties as big tents because people don't give the money to parties or to candidates anymore. They give it to these other groups. And that's in part because you can't drive the money out of politics unless you're willing to do something the American people are basically not willing to do, which is to have a really effective tax-generated system of public financing. Because it's not that too much money is spent in politics. I mean, let's suppose that the upcoming presidential election is going to cost $1 billion in campaign spending, which is probably pretty reasonable. That's about $4 or $5 for every person who's going to vote in the presidential election. That's not a lot of money. Right? If every American was willing to give $10 to the candidate they most cared about for president, it would drive all of the big money out of the system. But we're not willing to do that. And Jimmy Carter, who was in many ways a more perceptive person than a president, once promised to give Americans a government that was as good and decent and kind and generous as the American people. Right? Well, we get the government we pay for. Right? We get the government we pay for. And if we were prepared as a country to finance the presidential election and to finance other elections in an effective way, we wouldn't be so worried about Sheldon Adelson financing the elections for us. Right? And we wouldn't have most of the candidates who run for Senate in a lot of states being millionaires because they're the only people who can finance themselves. But it's not really the problem. The problem is not really just, corporations being treated as persons, because there are a lot of areas where I think we would all agree they should be treated the same as persons. Yes, sir?
Thank you. You commented on the position of the Obama administration in the Jones case, and I wondered if you could comment a little more generally. We've got a president who was a constitutional law professor. We had a previous Democratic president who was a law professor, I think taught constitutional law as well. They run as progressives, but their administration often takes positions that drives progressives crazy, although not consistently, because I guess Obama is now declining to defend DOMA. I wonder if you could just talk generally about what we can expect, what surprises you, what doesn't surprise you in terms of what we get out of a Justice Department run by a Democratic administration that runs on progressive principles.
Well, one thing is that we have to change the debate on some of the issues, and the political calculations within the administration have to be ones that it matters to a significant group of people what position they take. I'll tell you just one area where which ACS is very concerned about, where we've seen this play out, and that is judicial nominations. There are like 100 empty seats on the federal bench right now. When the Republicans came in 1980, they recognized that in order to change what the Constitution means, they needed to change who the judges were. And they needed to have a conscious strategy of appointing people to the bench who were going to move the Constitution in the direction they wanted to move it. And so they would throw up dozens of movement conservatives at a time, recognizing that some of those people would get shot down in the nomination process, but they get a bunch of them on the bench. And there's been a study done by Micah Schwartzman, who's a professor at UVA, that shows that on average, President Obama's nominations to the bench are 5 years older at time of nomination than George H.W. Bush or George W. Bush's nominees. Well, what does that mean? It means that the Republican, every time the Republicans have the nominating process, they nominate people who are going to be there longer than the Democrats do. And there were meetings by large numbers of groups, civil rights groups and the like, with people in the White House about the importance of getting people who share our views about the Constitution onto the bench. And we were told essentially the base doesn't care very much about that. The base cares about other things. Nobody is paying a huge amount of attention to this, so it's not worth expending a lot of political capital. The example I'll give that's probably familiar to a lot of you involves my co-author, Goodwin Liu, who's now a justice on the California Supreme Court, who was nominated by the White House for the Ninth Circuit. He was the only young, liberal Court of Appeals nominee up for many months at an end. Well, what does that mean? It means he can be sniped at and picked off, as indeed he was. Right? And, you know, that's going to happen. It's happening to Caitlin Halligan, who's a nominee for the D.C. Circuit, and it's happened to a couple of other people. And that's because the White House has to make political calculations about which are the areas that are going to have the biggest bang for the buck. The other thing is there was a fascinating article by Justin Driver, I think it was in the New Republic, about the kind of constitutional professor war for the soul of President Obama, which is between an old style of constitutional law exemplified by Professor Lawrence Tribe from Harvard, which is people who still pine in a way for the Warren Court era, and who think judges can do great things for access to justice, for equality and the like, and a more modern version of liberal constitutional thought, exemplified by Professor Cass Sunstein, who's also a co-author of mine on a constitutional law casebook at the University of Chicago, which is courts are not where the big battles are today. The big battles are in administrative agencies and in legislation. And so more of your efforts and energy should be focused at that. And the problem is, if you really let the other side take over the courts, you can have all the legislation in the world, and not much is going to be done by it. There's a famous and apocryphal, obviously, as you'll see in a moment, story about Joe McCarthy. Not Joe McCarthy, the satanic senator from Wisconsin, but Joe McCarthy, the famous manager of the New York Yankees in the 1930s. And he dies, and Satan comes to him and says, let's play a baseball game. And Joe McCarthy says, I'm going to win. I've got Babe Ruth, I've got, Honest Wagner, I've got Lou Gehrig, I've got Christy Mathewson. I have all the players. And Satan looks at him and says, yeah, but I've got the umpires. And the thing is, you can pass great legislation. We actually don't, there are some areas of law where we do need some new legislation, but there are an awful lot of areas of law where if the Supreme Court and the lower federal courts would just enforce the law that's on the books, we would be fine. If they just enforced Federal Rule of Civil Procedure 12 and 8 as they existed, we'd be fine. If they actually enforced the Federal Arbitration Act the way it was written, we'd be fine. If they thought more about Title VII and how it was actually written, we'd be fine. The Americans with Disabilities Act is a great statute. Right? We don't need new statutes there. What we need are people who enforce the statutes. What?
You were preaching. He said,
You're getting support from the back.
Yeah. Thank you, Lord! No, but I mean, that's what I think we need, so. And what else we need is to go home. So, thank you very much.
Here. Thanks to you, everybody, for coming. And please, again, don't forget to sign up for the ACS billing list. I think the sign-up sheet is right over there. So if you're not already on it, please sign up and become a member. Continue to be involved. Thanks again for supporting the chapter.